All right, welcome everybody to the Permanent Establishment webinar. I'm your host, Benjamin Allery. This is part of a regular webinar series that we run here at Blue Jay Legal alongside Thomson Reuters to talk about tax foresight and how you can use machine learning to predict outcomes in areas, various areas that tax foresight addresses. So today we're going to be talking about predicting judicial decision-making with machine learning. The topic is going to be the question of whether or not a certain taxpayer has a permanent establishment in Canada. And by way of background, for those of you who are somewhat less familiar with the idea of a permanent establishment, this is a question that often comes up in the context of non-residents of Canada who are resident for tax purposes in some other jurisdiction with which Canada has a tax treaty. So if Canada has a tax treaty with another jurisdiction, this question of whether or not the non-resident taxpayer has a permanent establishment in Canada is really important because that's a threshold for establishing source-based taxation on that non-resident's Canadian income. And so otherwise, if you're a non-resident coming from a non-treaty jurisdiction, the test will be the lower threshold, not this higher permanent establishment threshold, but a lower threshold, whether or not you're carrying on business in Canada. That will be determinative of whether or not you are taxable in Canada. And so given the size of Canada's treaty network, we have dozens of treaties with the most common economically developed jurisdictions around the world. It's often going to be the case that investors or business people or entities coming into Canada carrying on business are going to be coming from a treaty jurisdiction, a treaty partner. And so this question of whether or not that that entity or that person or that individual has a permanent establishment in Canada is going to be really important for determining the taxability in Canada. It won't be necessarily the carrying on business test. We've had carrying on business in Canada webinar already. Now it's time to take on this permanent establishment question. And so my goal today is to take you through kind of the background, some of the context around using machine learning, using tax foresight to figure out how courts are exercising their discretion. I'm going to talk to you at a high level about how we think about predicting how judges will decide cases, how they'll exercise their discretion, how we approach this using machine learning, and then we'll work through a specific example. So we're not going to leave this at a theoretical discussion about machine learning and how you can use machine learning in tax law. We'll make it very practical, and we'll work through an actual example so you can really see how tax foresight can help you in your tax practice, whether you're an accountant or a lawyer or if you're in government. As well. There are many use cases of the software. Some big corporations are also using tax foresight to help figure out their tax situation. So really excited to get into this, exploring this permanent establishment question, and let's kick this off. Okay, so the way that we think about using machine learning to do tax research is that we really regard this as an evolution of different legal research tools that we've seen for a long time. So we see a lot of legal research obviously taking place in an analog setting, using real paper, using real books, and that has a long history. The first income tax started in the UK right around 1800. With the first income taxes there. And obviously everything was driven by paper. Long before that, of course, Gutenberg and the printing press made mass production of legal reference materials quite possible, led to a major innovation in the legal system. And that proceeded for several centuries up until about the 1970s. And then we saw the advent of a new way of doing legal research and the advent of digital legal research. And so for virtually everyone today, you would have grown up with a mix of different kinds of research methods, digital and analog, side by side, unless you're a really new practitioner, in which case maybe the vast majority of your research would have been done digitally. But for most of us, and I'm 40, so I'm a little bit older, we spend a lot of time dealing with both analog materials and digital materials as well. And what we've seen with digital materials is they've grown fairly significantly over the years. So in the early 1970s, the materials that were available in digital format were really quite limited. In the past nearly 50 years, what we've seen is virtually everything being made available in digital format, the digitization of vast back catalogs of information, as well as all the new materials, new cases as they're decided, legislation, regulations, everything is routinely made available in digital format. And it's often originally produced in digital format. So it's not a question of, oh, you take the analog version and then you digitize it and work with it that way. No, instead, the government, the legislative drafters, the people working with these materials, actually creating draft legislation, the judges crafting their judgments are working natively in digital formats. And so everything's virtually available in digital format now. But that presents a really exciting possibility that we see emerging with this computational turn in legal research. So with everything becoming available digitally, we've got all this information, all the case law, all the legislation, all the regulations, everything available digitally. Means that we can take the computing power that is increasingly powerful, right? Following Moore's law, we see rapid and continuing increases in the computing power that's available to analyze digital materials. So we've got the digital materials themselves, we've got the computing power increasing over time, and we've got algorithms. Algorithm is just a fancy word for formulas, right? Or methods or processes. We've got algorithms that are able to synthesize those digital materials using a lot of computing power to make sense out of it for legal researchers. So this is really, really exciting. This is something that's only really become possible in the last few years with the rise of cloud services, machine learning platforms, improvements in the algorithms, improvements in computing power, and the digitization of all of these materials. So we have these three key ingredients. We've got the digital data, we've got the computing power, and we've got the algorithms, the formulas for figuring out what all of this digital information means. And so what this means for us and what it should mean for you, if you're looking at using these computational methods for figuring things out in the tax context, is that you can actually use new methodologies to conduct your research. And that's what we're going to be talking about today. How does tax foresight draw on predictive analytics, machine learning, artificial intelligence to predict how judges are going to be exercising their discretion when they approach a new question? It's really exciting for us, and it's something that's got a ton of power, a ton of promise, and we continue to build new functionality in the software. You might say, okay, theoretically, that's very interesting. So I understand the paper to the computer and then the computer to this computational thing, Ben, I get it. But what does it actually mean for me? What does it mean for my clients? How do I actually use this? Why would I use this? And for us, we think that it means three big things for you. One, you can provide your clients with the highest quality legal advice possible. So one of the things that clients look for when they retain an accounting firm or a law firm, or even in government, one of the things that's really important if the Department of Justice is advising the CRA, just as an example, what they are going to want to be doing is providing their clients with the very best possible advice. And so that's something that users of Tax Foresight can actually leverage in providing that advice. It's a way to very, very quickly validate your instincts. So as a professional, if you have many years of experience in an area, even if you're a specialist or maybe even a generalist who's looked at a particular issue a number of times, you'll have certain instincts that you have about how judges are likely to decide new cases in an area. You'll have your interpretation, a general sense, and maybe it's a gut feel for some of you. Maybe it's your spidey senses. I don't know how people describe their intuitions about how judges are likely to analyze cases. But whatever it is, users have instincts that they seek to validate using these sorts of methods. So users of Tax Foresight are, of course, trying to provide their clients the highest quality legal advice. Sometimes it simply is a double check. So you know that you've worked in an area before, you've looked at a number of cases, but you know that you haven't read every single judgment in the area. Maybe you haven't worked in an area for a few months. You're not sure if there have been recent cases that might have changed the trajectory of how judges are deciding certain cases or exercising their discretion in an area. This is just a very quick way to double check your instincts on the legal questions. You may say, well, I think it's very likely that my client is in a good position here. And you can turn to tax foresight, analyze that fact situation, and get a prediction about what the courts would actually do. And the nice thing about that, our users tell us, one of the nice things about that is allows them to be more confident in the position that they're taking and say, yes, I've satisfied myself that the hundreds of cases that have come before are consistent with the position that I believe my client is in, and so feels good to be taking the right position. The other thing that they tell us is that it's really, really useful to be able to quantify risks for clients. So one of the things that clients often want to know is that they're getting the very best possible advice. So the service provider that they're seeing, whether that's a tax accountant or a tax lawyer, is providing them with the very best advice possible. Second, that the service provider has done their due diligence to actually validate their instincts. So one of the reasons why you approach service providers, because you trust their instincts, you trust their professional experience, you trust their judgment. You want to know that they're actually keeping up to date and up to speed with all the latest cases that are coming down. And one of the things that you really want to know if you're a client is, okay, I want the highest quality advice. I want my service provider to be validating their instincts. Why? Because I want to know what it means for me as the client. Is my position likely to be validated by a court? Is this something that the court would actually agree with if this were to go to court? And clients don't want to go to court typically. They just want to have a quiet life. They want to settle. They just want to be either correct and have no issues raised, or they know that they're correct if questions are subsequently raised and be able to justify the outcome. And so one of the really nice things about using software like Tax Foresight is you can quantify the risk for a client and say, yes, it's 90% likely that you're in the clear on this particular case, or maybe it's 70%. And then even just knowing that and then understanding as the client, okay, it's 70% that this is good, so it's more likely than not. Okay, so I'm comfortable with that risk. Whatever it is, clients like to know just where they stand. And so users who are able to use this kind of computational methodology are able to provide their clients with that kind of comfort about the situation, the tax position that they find themselves in. So very, very valuable for all three of these reasons to use these computational methods in providing advice. Okay, so specifically, what is it about the Tax Foresight solution that allows our users to do these three things? So provide the highest quality advice, validate instincts, and quantify the risk. Well, there are two different major parts of the software. One is all about search. So on the search front, we have a case finder functionality and case analytics. These functionalities allow you to find the cases that share certain facts in common with the fact situation of your client. So you can drill down and find very, very quickly those cases that share those same factual features that your client has in their situation. This can be very, very helpful as compared to a keyword search. So if you're just using a keyword search to try to locate cases, you will likely find a lot of cases that raise the same legal issue or the same tax issue that you're looking for. But what you're not searching for, by and large, are the cases that share the same factual fingerprint as the case you're looking for. Case Finder will help you find those cases that share the same factual fingerprint. So very, very useful to use the search functionality within Tax Foresight. The answer functionality is mostly what I was focusing on in the prior discussion of, for example, quantifying the risk. So the answer functionality basically steps users through a question and answer process. You log in and you select the relevant classifier. We today are going to focus on the permanent establishment classifier. So you're going to see this in action. We're going to log in, look at a particular situation that actually went to court and used the permanent establishment classifier to see how a court would likely analyze this case. And so the classifiers basically collect all the facts from you as the user that relate to a client situation, and then it takes that set of facts and how those facts relate to all the previously decided cases and gives you a prediction about what a court would do based on all of those previously decided cases. So those classifiers are really using machine learning, leveraging computing power, the digitization, the algorithms to actually produce these predictions. We address a bunch of different issues. Real estate transactions, are they income or capital? GAR, residency determinations, carrying on business I mentioned earlier today. Of course, our focus is going to be on permanent establishment, and there are 20-something issues that the software now addresses. So tons of stuff, the most commonly arising issues in Canadian tax law. It's really, really accurate. So 90% accuracy in out-of-sample testing. We assess the accuracy of our algorithms in a couple different ways. One way is during the training phase, when we're training the AI about how courts are exercising their discretion in different fact situations. We basically collect all the facts of the cases and link it to the outcomes of those cases. And the AI is able to learn from sets of facts and the related outcomes. And we give them, the algorithms, tons of examples. And so what we do is we collect all the cases in an area. We take 70% of those cases that have been decided and we select them randomly. We train the algorithm on those 70% of the cases. We're holding 30% of the cases in reserve for evaluating the accuracy of the algorithm. So we're training it on 70% of the cases, showing the algorithm the facts and showing the algorithm the ultimate outcome of the case. And the algorithm's able to understand the patterns in the facts and how they relate to the outcomes in the cases. Then we take the 30% of the cases that the algorithm hasn't seen, and we present the algorithm with the facts of those cases and say, okay, algorithm, how well have you learned? Can you tell us what your prediction is in this area? And the algorithm says, yes, I predict X or not X, as the case may be. And then we compare what the algorithm predicts with respect to those 30% of the cases with what the courts actually did in those cases. And what we're finding is we're getting about 90% of those cases right. In the 10% of those evaluation cases, or in the assessment cases that we're not getting right, what we tend to notice is that the algorithm isn't particularly confident about its predicted outcome. So it tends to be a little bit self-aware about what cases are more marginal, which ones are less marginal, and so the ones that it gets wrong, it's tending to say, this could go either way, but my best guess is X, or this could go either way, but my best guess is not X. Those are the ones that it's tending to get wrong. And so it's very, very interesting. It's very helpful as a user to know that 90% of those cases are accurately predicted. That's the first way in which we make this claim that the tax foresight software is getting about 90% of the cases predicted accurately. The second way in which we test this and monitor the accuracy of the software is with respect to new cases as they're decided. So as the tax court, the Federal Court of Appeal, the Supreme Court of Canada are deciding new cases, we're updating the software every week with the new cases that are being decided. And as we engage in that update process, before we update the software, we run diagnostics and we say, okay, so based on these facts, what would you say, algorithm? And then we get the predictions in all the different areas. What we're finding is that software is extremely accurate, again, in predicting these cases, that there's no way there would have been for the algorithm to have predicted that, but for actually being pretty good at predicting outcomes. So for example, one of the classifiers we just updated had 14 recent cases that were decided by the courts from the last time we updated it. And we got 14 out of 14 of those cases right. It's really gratifying to see that as an entrepreneur, and seeing that the software is actually really, really accurate in predicting what the courts are doing. And it's a huge part of the value proposition. You want to be predicting what the courts are likely to do in new cases. That makes your clients very happy to know that you're tapping into all of this knowledge that's embedded in all of these cases that have previously been decided. And this is a fantastic way to really leverage all of those cases in a very quick way. It leads you to having happy clients who are well advised, makes your life easier. You're writing off fewer billable hours in terms of taking extra time to do research. You can spend those research hours laser focused on precisely the right cases using this kind of software. Okay, and don't just take my word for it. We have some amazing clients coast to coast right across Canada using the software. This is just a smattering of them. We have, I believe, 87 different organizations now subscribing to the software. Lots of really big names, as you can see on your screen. Other big names that are not up there, but tons and tons of take up of the software, and more firms are approaching us every day, asking us to come on because they know that this is the way that these things are going. Another driver of this actually is that TaxNet Pro recently introduced a whole bunch of integrations with Tax Foresight. So if you're on TaxNet Pro and you're doing research, for example, on permanent establishment, what you'll see is if the case appears in the permanent establishment classifier, if it's one of the cases that we have trained our algorithms on in making these predictions, there will be a reference to Tax Foresight now within TaxNet Pro. So this is really fantastic. It's a nice indicator right within TaxNet Pro that Tax Foresight addresses this issue that you are investigating while you're doing your tax research on TaxNet Pro. And so if you click on Tax Foresight, it'll take you out from TaxNet Pro to a Tax Foresight classifier, and you'll be able to run your analysis right there on Tax Foresight. Now, of course, you need to be a subscriber to Tax Foresight to tap into that functionality, but it's extremely valuable for you to be able to know that there is that Tax Foresight classifier right there, and it's a prompt right within your ordinary workflow on TaxNet Pro to access that. So just a little flag, those integrations only went live a couple weeks ago, already seeing significant traffic from TaxNet Pro into Tax Foresight. So something that people really, really value who do tax research all the time. Okay, so let's turn now to the permanent establishment classifier and the topic of this webinar. So the research question that we're going to ask, and it's a very specific research question here, as these often are, part of the research exercise is really nailing down precisely what is it that is your research question. What is precisely the issue that we want to investigate? And so here, we're going to focus on an entity that is a United States resident for tax purposes, because if it were a Canadian resident, it wouldn't be as much of an issue. Then we'd be talking about a treaty tiebreaker sort of analysis, and the residency classifier can conduct that analysis. So we're dealing with a known non-resident. The question is this non-resident of Canada, who is a United States resident, does that US resident have a permanent establishment in Canada pursuant to the definition or understanding of permanent resident in Article 5 of the Canada-US Tax Treaty, and specifically with respect to two of the different paragraphs of Article 5 of the Canada-US Tax Treaty. So we'll jump into those paragraphs. We'll have a look at that language in a moment, but it's important to have very, very clear in our minds that this is the research question that we're hoping to answer. Half the battle is getting the right question pinned down. As I teach my law students who take tax with me at the law school, it's all about identifying the right question to ask. So knowing that this is the question that we're asking, let's look at the facts. So what are the facts of the case that we're going to consider? So we're going to look at a case that was decided about 10 years ago, and this case is called the Knights of Columbus. So many of you will know this organization, the Knights of Columbus. The Knights of Columbus is formally organized as a United States corporation. It's a fraternal organization. And part of what the Knights of Columbus does is it provides life insurance to Canadian members of the Knights of Columbus. And so as a US resident, it's providing these life insurance policies, this life insurance coverage to Canadians. And to do that, obviously, the Knights of Columbus needs some kind of distribution channel. So it doesn't just happen on its own. And so there are 220 field agents who are actually responsible for going out and sourcing the Canadian members who are going to sign up for the life insurance, 22 general agents. So each of those general agents basically supervises 10 of the field agents. Then there's one field director who's an employee of the Knights of Columbus out of the US, and then a chief agent. The chief agent is really a role that is related to the regulatory auspices of OSFI, so the Office of the Superintendent of Financial Institutions in Canada. So you need a chief agent by the regulations as I understand them. So we've got this distribution channel, hundreds of these agents, a fairly flat organization, lots of field agents, and then many fewer general agents, and then just singletons, field director, a chief agent. Now, the issue here is whether the Knights of Columbus, as a US resident, had a permanent establishment in Canada, and what are the stakes involved? So if those agents constitute a permanent establishment in Canada, then ostensibly the Knights of Columbus should be taxable on the business profits associated with the Canadian source income. So if there's a permanent establishment, that's the threshold for taxation in Canada. Then those life insurance profits that the Knights of Columbus is generating from the Canadian members will be taxed in Canada, subject, of course, to the treaty and everything else. But that's the basic question. So is there a taxable presence in Canada for the Knights of Columbus with respect to these field agents, the general agents, and also with respect to the life insurance policy that those agents are responsible for helping to get members in Canada to sign up to? So this case was decided in 2008. We're going to look at these facts, but we're going to be using tax foresight to help us answer this question. So now I'm going to jump into tax foresight. So I'm logged in here. You should be able now to see my screen, and you'll see that this is the normal login screen. You log into tax foresight. Here's what you see, and you'll see my favorites. I don't have the permanent establishment thing here as one of my favorites, so I can use this quick find functionality and just begin to type permanent establishment, and there we go. We see that we've got a match under one of the jurisdictional topics, which is permanent establishment. I can back this out and just show you. We've got a ton of different functions here. So the worker classifier, gross negligence penalties under subsection 163(2) of the Act, whether or not the minister can open up older assessment periods. You can check this out. Whether or not something's an exempt financial service under the Excise Tax Act for GST, HST purposes, a ton of income versus capital functionality here, trading securities, real estate, tangible and intangible expenditures. So whether something's a current expense or a capital expenditure, things relating to different sources of income, business versus property on the rental property front, wagering gains, so windfalls, worker classification, then some questions around different kinds of inclusions, shareholder benefits, really common to get these questions, taxable benefits, whether the primary beneficiary of a particular expenditure is the employer or the employee for the purposes of paragraph 61A of the Act. Taxable benefits more broadly, this is a navigator, so this helps you figure out what the CRA's view is on different kinds of taxable benefits. You can navigate through the CRA's guidance, a whole bunch of issues around deductions. Interest deductibility is a huge issue. Can I deduct that interest expense under paragraph 21C? Bunch of jurisdictional issues. Here we see the permanent establishment one, but the residency issue, am I resident in Canada for tax purposes? Carrying on business, which is the threshold if you're a non-resident coming out of a not treaty jurisdiction for income tax purposes. But carrying on business is also relevant for GST, HST purposes. Do I have to be a GST, HST registrant? And so you can use the carrying on business classifier for those purposes. Central management and control. Is my corporation centrally managed and controlled from Canada for the purposes of figuring out corporate residency? Whole whole bunch of stuff on penalties, the GAR, very popular case finder to find those cases in GAR that might relate to your issue. So tons of stuff here. And then on the indirect tax side, the exempt financial services functionality that we saw up above is one of my personal favorites. And then single versus multiple supply is also here. So tons of functionality in the software. We're just going to focus on the permanent establishment piece. And for now, we're going to focus on the answer giving piece of this. So this is the classifier. This is the part that's actually going to conduct an interview of us, collect all the facts from this Knights of Columbus example, ask us a whole bunch of questions, and then tell us whether or not the software thinks that the Knights of Columbus had a permanent establishment in Canada for the purposes of triggering that threshold of taxability in Canada. So I'm going to click here on the classifier function. It's going to take us to this initial screen. So this initial screen, this landing page, is really helpful. It tells you what the purpose of the classifier is, how this classifier addresses your research question. And so what we need to do is be confident that this classifier is up with the research question that we're actually posing. Remember, we were asking whether or not the Knights of Columbus have a permanent establishment in Canada according to Article 5 of the tax treaty between Canada and the US, and more specifically under paragraphs 1 and 5 of that treaty. So we see in paragraph 1 of this article that for the purposes of the tax treaty, the term permanent establishment means a fixed place of business through which the business of a resident of a contracting state is wholly or partly carried on. Okay, so here the question is going to be, are the Knights of Columbus carrying on this business through a fixed place of business? And so this is going to basically require us to characterize the places out of which these field agents and others are carrying on the business of selling these insurance policies to members of the Knights of Columbus. Paragraph 5 says that a person acting in a contracting state on behalf of a resident of the other contracting state, other than an agent of an independent status to whom paragraph 7 applies, shall be deemed to be a permanent establishment in the first mentioned state, so that's in the United States here, if such person has and habitually exercises in that state an authority to conclude contracts in the name of the resident. So this is essentially the dependent agent kind of idea. So if you have an agent that's dependent upon you as the distribution channel for selling, even though the Knights of Columbus as a corporation is resident in the United States, if they have agents in Canada who are dependent upon them and have authority to conclude contracts in the name of the Knights of Columbus, the resident of the US, then that will be deemed to be a permanent establishment. Paragraph 7, a resident of a contracting state shall not be deemed to have a permanent establishment in the other contracting state merely because such resident carries on business in that other state through a broker, general commission agent, or any other agent of an independent status, provided that such persons are acting in the ordinary course of business. So paragraph 7 says it's okay, you can conclude a contract through an independent agent. So as long as that agent is independent of you, then it's okay. But it has to be that they're carrying on that business as an independent operator, and that independent operator is acting in the ordinary course of their business. So so that's a gloss that paragraph 7 provides. It's also important to understand here that this classifier doesn't apply to certain things. So you still need to look at the text of the tax treaty, but this will help you figure out what do we make about the dependent agents here. Would a court say that they actually had the authority to conclude contracts in the name of the resident, and did they have a fixed place of business? And so we're going to work through this and analyze the situation. You'll see that this was last updated last week, and less than 1% of our users disagree with the results of this classifier. So very, very powerful vote of confidence in the outcomes predicted by the software today. So I'm going to click next here, and it's going to start asking us questions about the situation here. So fixed place of business. Does the US resident have any facilities, premises, equipment, or machinery in Canada? So let's see, this will trigger a set of questions. I'm hovering over this little I button here. This will trigger a set of questions relating to a potential permanent establishment via the fixed place of business provision in paragraph 1. If you're concerned about a potential fixed place of business permanent establishment, select yes. Yes, we are here. This is the government's position, is that they have a fixed place of business in Canada. So I'm going to click yes here. In a few words, describe the place. So what I'm going to say is that we're worried about characterizing the home offices of these field agents. So these field agents work out of their own home offices, and they're provided with a bunch of materials from the Knights of Columbus. So they get a rate book, they get cards and letterhead that they can use as field agents to help place these policies with Knights of Columbus members, and they operate out of their own homes. So it's not that the Knights of Columbus actually owns these home offices or necessarily controls these home offices, but the field agents do have materials that have been provided to them from the U.S. resident, the parent corporation here. They've been given these materials, and they're hosted in 220 different home offices right across the country. So I'm going to describe the place as home offices of field agents. What is the total number of days the U.S. resident has had a presence or carried on activities at the place? Okay, so having a presence includes brief visits. So it's kind of hard to figure out what this means in this particular case. What's the total number of days? Okay, so the U.S. resident, that's the corporation. I would say that it's like all year that these activities are carried on at the place. How many days does it have a presence or carry on activities? So this is in this particular year. How many days per year on average? I would say they're active all year, every year. Are the activities of the U.S. resident at the place a one-time activity or for a one-time transaction? No, these are ongoing things. The U.S. resident doesn't really have a legal right to these home offices, right? So they don't have a legal right to the home office. Let's look at the tooltip here. Having a legal right includes having access to the place through lease or ownership. Yeah, so this isn't really true here. Okay, has the U.S. resident paid for any of the expenses relating to the place? No, these field agents obviously pay for their own home. This is an expense that they bear. Has the U.S. resident paid for any of the expenses for the equipment used at the place? So it depends on how we want to characterize equipment here. I think I'm going to say no. We can come back to this question. There are questions about just whether or not these rate cards are de minimis. They were given some other tools. They were given some, I think, some testing equipment for spit tests, other kinds of things. So let's just say no. We can come back to 1.8. One of the things we can do here is actually change some of these answers and see how it changes the prediction, if at all. 1.9, does any entity other than the U.S. resident have a presence or carry on activities at the place? Well, here, yeah, I mean, if it's a home office that is used exclusively, well, it's not used exclusively for the purposes of the U.S. resident here, because these are home offices. They're probably something else going on. This is another kind of question that we can double check here. But I'm going to say, does any entity other than the U.S. resident have a presence or carry on activities at the place? I think yes, because these individuals likely do other things in their home offices. It's not that the Knights of Columbus has sole domain over that home office. There's potentially other things happening in those home offices as well. Are the activities being carried on at place part of the core business of the U.S. resident? This one is probably no. The core business of the Knights of Columbus is as a fraternal organization. The insurance element is one part of their business. The evidence is that it's 20%, 20 to 25% of the revenues of the Knights of Columbus come from insurance. We could probably say that that's not the core functionality of the Knights of Columbus. It's an important part, but out of these field offices, this is not a core part of the business of the U.S. resident. Is the address or telephone number of the place listed in a directory or document under the U.S. resident's name? This is for sure no, because these are just home offices. The field agents really are active in the field, so they're not principally working out of their home offices. That's just, they have to have a bit of a home base, and that's their home base for lack of any other home base, but it's not that they're really listing their home offices on any kind of directory or on a document or so on. Is the place identifiable as being part of the business of the U.S. resident? No, there are no signs up, nothing like that. Does the U.S. resident have any of its personnel at the place at any time? Arguably not, since the personnel are the worker's home office, and it's only that specific worker who's at the home office. So I'm going to say no, and that's consistent with the tooltip here. It's these field agents are independent contractors of the parent company. They're engaged on a contractor basis. They're not employees of the Knights of Columbus. What is the percentage of the U.S. residents' total worldwide income that's attributable to the place? It's really small. I'm going to say it's 20%, just for the sake of argument. And here, place would have to be construed in a very broad way, as including all of these home offices. I'm going to say 20%. That's probably on the high side, and it's one of those questions we can go back and see how it influences it, and play with that number and change it to 2%, and maybe leave it at 20% or change it to 90%, and see just how sensitive the predictions are to altering this number here. And it's one of the cool things about using the software. When I teach at the law school, I teach tax, I teach international tax. Often we will talk about situations involving this kind of discretion and what really should count as a fixed place of business. And we play with the hypotheticals and we say, okay, these are the facts of the case, but what if we change this? What if we change that? And we have a discussion, often rather intuitive and policy-based. Well, that should count, that probably shouldn't count. And we try to get a sense of what the underlying treaty language is attempting to capture, and then try to predict how judges would actually interpret it and apply it. The power of this software is we can check, based on all the existing cases, how those different elements would actually likely play out in court. So it's less of a thought experiment as really an experiment that we can play on the existing case law. So I'm going to click next here. Is there a person in Canada who acts on behalf of the U.S. resident? So this is basically the other part of our research question. I'm going to say yes. In a few words, I'm going to describe field agents. Does the agent have and habitually exercise in Canada an authority to conclude contracts in the name of the U.S. resident? So here in the agreement between the Knights of Columbus organization, which is resident in the United States, and the field agents, it's very clear that they are given no authority to conclude contracts in the name of the U.S. resident. This is actually no. So there is a question, I think, about whether, so the field agents, I've said no. So the field agents, probably not going to lead to a dependent agent. So let's see, let's talk about the other agents, because we have the general agent. So let's talk about the general agents here. Does the agent have and habitually exercise an authority to, let's just proceed on this basis. Let's say we know 2.3, if there's no authority to conclude any of these agreements, then there's no issue. And actually, in the case, there was an issue around what happens when a field agent gets someone to apply for insurance coverage Usually there's a temporary period of coverage after you apply that leads the individual to have coverage while that application is being considered. So it's a nice thing that the field agent is able to say, well, if you apply for this coverage, once you apply for the coverage, you will be covered until until Knights of Columbus actually makes a decision about whether to extend you formal coverage. So let's see. And so there could be, and there were issues in the case around whether this temporary insurance agreement actually constitutes the discretion or constitutes authority to bind the Knights of Columbus. Okay, does the agent generally have freedom and discretion to perform the business activities of the U.S. resident in Canada? If the U.S. resident determined the work to be done by the agent and gave instructions as to how the work should be done, select no. If the U.S. resident did not supervise the agent and had no control over how the agent performed the work, select yes. Okay. So I think the general agents did actually have kind of mixed monitoring by the Knights of Columbus. I'm going to say that they generally had freedom and discretion, not complete freedom and discretion, but they did generally have freedom and discretion. Other than the loss of work, is the agent personally at risk of loss? No, not really. So no, they're not really at risk of loss here. If you're a general agent, it's not clear how you actually are going to lose money. Does the agent have the opportunity to profit by his or her own entrepreneurial skills and knowledge? For sure. If you're one of these general agents and you can organize your field agents effectively, you would have the opportunity to profit by your own entrepreneurial skills and knowledge. Does the agent have special skills or knowledge that the U.S. resident relies on for its business activities? Yeah, for sure. How to motivate and get those field agents to perform. Does the agent represent or assist any other enterprises apart from the U.S. resident? This would be a question of fact here. It's a good question. 2.8 is something that we can come back to as well. I'm going to say yes here. Is the work relationship between the agent and the U.S. resident a one-time only relationship? No, this isn't just a single transaction. These are general agents who actually have this ongoing. How is the agent compensated? It's based on commissions. Is the agent acting in the ordinary course of his or her own business when carrying out activities for the U.S. resident? I'm going to say yes, these general agents are doing that. Okay, so looks like we've answered all the questions necessary to get a prediction here. You'll see we've answered 25 questions here. So Tax Foresight has harvested a bunch of these factual dimensions of the case. I've jotted down a few of them. So for example, 1.8, 1.9, 1.14, 2.4, and 2.8. We're going to play with these different issues, but when I click compute here, we're going to get a sense of what the software's prediction is about what a court would do if confronted with the specific way we've answered the questions here. Okay, so the software is very confident, 89% confident that court would say no permanent establishment in Canada on this particular set of responses that we've given. So very, very confident outcome. Very interesting. What else do we see on this result screen? So we've got the result, no permanent establishment. You can see the confidence over here. We're confronted immediately with a number of different questions about, well, let's do some scenario testing. What if the U.S. resident had a legal right to the place? So what if the Knights of Columbus had actually leased out space for all of these field agents and the general agents to use? How would that have changed the fixed place of business analysis? I'm tempted to find out now, so I'm going to click find out. Okay, it wouldn't have made that much of a difference, so still 80% unlikely to have a permanent establishment. I'm going to click this back to restore it to the actual facts of the case. Okay, 89% should be, yep. And then a whole bunch of other things like what if the places were actually listed under the U.S. resident's name, Knights of Columbus? What if the agent doesn't have freedom and discretion to perform the business activities of the U.S. resident in Canada? What if the agent doesn't have the opportunity to profit by his or her own entrepreneurial skills and knowledge? We can test all that stuff out. But what I really want to highlight are the other elements of the results here. So the system will generate an explanation about why this is the outcome. So as a reminder, we see no permanent establishment, 89% likelihood. This explanation is really sensitive to how we answered all of these questions around the fixed place of business and the dependent agent. So it explains why that's the likely case. So I can click more here, and it's just going to expand that a little bit. And we're going to see the explanation actually dives into this in a fairly detailed way about why it would be likely that a court would say that there wasn't a permanent establishment in this case. We can see the software has gone through and identified the most similar cases out of the case law here. Interestingly, there are cases that have gone both ways. So it's understandable why the minister challenged the Knights of Columbus here, because if you just look casually at this list, 1, 2, 3 of these cases said no permanent establishment. 7 went in the direction of permanent establishment. What's really cool is that the machine learning software is able to make a prediction that doesn't just look at those base rates and say, well, you know, the most 10 similar cases said permanent, the majority of the 10 most similar cases said permanent establishment, therefore 70% chance likely permanent establishment. No, it's actually diving into the facts and looking at how they interact with each other and saying, look, the overall likely, the best response here is it's not a permanent establishment. You can see hovering over the similarity bar, the things that are most similar and most dissimilar in the facts of the case here. If you wanted to find more cases, you could click on that. That would launch the case finder functionality. You can get into that. The software also identifies the most significant references in the area, the references that are most important here. And so you'll see the Knights of Columbus is the #1 result here. If I click on the report functionality, it will download a report and give me all of these responses, all of my responses, the prediction of the software in a handy dandy PDF report. So it's downloading it. I can pull it up and I can add this to my research in support of my client's position, or I can share this with my client. A number of our clients, a number of our customers, our users do that on a routine basis just to justify the results. Okay, so let's go back. Let's change a couple of these answers. So I mentioned 1.8 and 1.9. What if we change 1.8 and say the US resident did pay for the expenses of the equipment used at the place? So, and let's say that there is no other entity other than the US resident that had a presence. So we now got exclusive use offices and the US resident paying for some of the expenses used at the place. We can recompute. So we can just go in, change that manually, recompute. What are the predictions? Okay, it actually didn't change the result at all. Very, very interesting. Here, what if we change this back? I'm just curious about remixing these, see if it makes a difference. Okay, so those don't have any purchase whatsoever on the result. What about 2.8 here? Does the agent represent or assist any other enterprises? No. Like, let's suppose this agent is only dedicated to Knights of Columbus. How does that change the result? Okay, so bumps in the direction of not as confident of finding that there's no permanent establishment, but again, the result is the same. Okay, let's go back. Let's change that 2.4 back to no, and let's change this. So I said, what if we change this to 2%? The direction of this should be in the direction of, okay, no permanent establishments, right? 98%. Okay, interesting. Okay, so we've got questions here. Someone's asked, does the software capture enough tax treaties to perform PE assessment? So this particular classifier is trained specifically on the Canada-US tax treaty. So It's based on all the cases interpreting the Canada-US tax treaty. A number of treaties have similar language and similar standards, of course. A lot of treaties have slightly different language for the permanent establishment clause, and the OECD model treaty has slightly different language. So we focus this specifically because there are enough cases on the Canada-US treaty to really analyze this question. We've focused on that part. So if we change this back to 20, we can get back to the results screen. So we've really focused this on the Canada-US tax treaty. This is part of the importance of focusing on a very particular research question when you're using software like this. Then you can play with it, try out different scenarios, and get a sense of just how sensitive the analysis is to the different factual assumptions that you're making. Okay. All right, so that's the classifier. Now, if I wanted to, maybe I'll get into it very quickly, just show you what the case finder looks like. So if I wanted to focus on cases, let's say I wanted to find cases where there was not a fixed place of business and where it was really about potential dependent agent, I would click on those things, and then I would find those cases that are a perfect match for those assumptions. Then I could refine this further, find cases by the agent's authority to conclude contracts in the name. Let's suppose that the agent does have the authority to conclude agreements. Okay, then boom, right away, I see that there's only one case that is a perfect match. It's this, this case from 1992. If I click it, it'll take me out to TaxNet Pro. I can continue on with my research in TaxNet Pro. Here I'm going to log in, and boom, I'm right into the full text of this judgment. I can do further research. And yeah, so there you go. You got the splash screen introducing Tax Foresight on TaxNet Pro. You'll see this here, and you can see some of the integrations here in action. If I go to the commentary, you'll see here Tax Foresight, and this is what I was referring to. You can see it's referred to in both the carrying on business and permanent establishment functions on Tax Foresight. I click here. I can click on the permanent establishment classifier. It's going to take me out to the permanent establishment classifier on Tax Foresight. So you can see Tax Foresight and TaxNet Pro working hand in glove. And it's really fantastic functionality. I urge you to check it out. We ran through a number of what ifs, including these what ifs. If you are interested in getting a walkthrough of Tax Foresight with one of our lawyers, I invite you to send the text message to that phone number. I'm going to leave it up for a minute, or send us an email, info@bluejaylegal.com. We'll get back to you right away. If you prefer, you can contact your Thomson Reuters sales rep. Lots of the sales reps have really great relationships with the TaxNet Pro customers. So if you're more comfortable talking to your rep, contact your rep. They'll get in touch with you and get you set up with Tax Foresight. We're out of time. Thanks very much for your time and attention today. Please check out Tax Foresight on TaxNet Pro. Check it out, taxforesight.com. If you don't have access, get in touch with us. We'll link you up. We can run you through some real life scenarios that you work through in your daily practice, and you can see the power of machine learning for your clients and for the tax advice that you give to them. Thanks very much.